If you're watching this video today, I know exactly what brought you here. Maybe you filed an I-130 petition for your spouse, your parent, your child, or your sibling months ago, and you're checking the mailbox every single day, wondering when you'll finally hear something. Maybe you're reading online forums late at night, seeing people talk about delays stretching into years, and you're asking yourself if your family will ever be together again. Maybe you've heard rumors that processing times are getting worse, or that certain cases are being prioritized over others, and you just want someone to tell you the truth about what's actually happening right now. I understand that anxiety. I understand that every day of waiting feels like forever when the people you love most are counting on you. And that's exactly why we're here today. In the next 13 minutes, I'm going to walk you through the real official USCIS processing times for I-130 petitions in 2026, explain what those numbers actually mean for your family, separate the facts from the rumors you've been hearing online, and give you practical guidance on what you can do right now while you're waiting. You're not alone in this journey, and you deserve clear, honest information. Let's begin. Let's start with the most important foundation. The I-130 petition, officially called the Petition for Alien Relative, is the first critical step in bringing certain family members to live permanently in the United States. This form is filed by a United States citizen or lawful permanent resident to establish the qualifying relationship with a family member abroad or already in the United States. Now, it's essential to understand that the I-130 petition itself does not grant a green card or permanent residence. What it does is prove to USCIS that you have a valid family relationship that qualifies under United States immigration law. Once USCIS approves your I-130, the next steps depend on several factors, including whether the beneficiary is an immediate relative of a U.S. citizen or falls under one of the family preference categories, and whether they're adjusting status inside the United States or going through consular processing abroad. But everything begins with that I-130 approval, which is why understanding current processing times is so important for planning your family's future. As of early 2026, USCIS processing times for I-130 petitions vary significantly depending on which service center is handling your case and what category of family relationship you're petitioning under. For immediate relatives of United States citizens, which includes spouses, unmarried children under 21 years old, and parents of U.S. citizens who are at least 21 years old, processing times at most USCIS service centers are currently ranging between approximately 12 to 18 months. Some service centers are processing cases slightly faster, while others are experiencing longer delays. For family preference categories, which include unmarried adult children of U.S. citizens, spouses, and unmarried children of lawful permanent residents, married children of U.S. citizens, and siblings of adult U.S. citizens, the I-130 processing times are similar. But remember that even after approval, these categories face additional waiting periods because of visa availability limitations based on annual caps and per-country limits. This is something we'll discuss more in just a moment. Now, let me address something extremely important that causes tremendous confusion and anxiety in the immigrant community. Many people see processing time estimates and believe these are guarantees or that cases are processed in strict order. The reality is more complex. USCIS publishes processing time ranges on their official website, and these are updated regularly based on actual case completion data. However, individual cases can and do vary. Some cases are approved faster than the estimated range, while others take longer. Why does this happen? There are several legitimate reasons. Some petitions require additional evidence or documentation. Some cases are selected for additional security checks or administrative processing. Some involve complex situations that require more review time. Some service centers are experiencing higher volumes of applications than others. And occasionally, USCIS transfers cases between service centers to balance workloads, which can affect timing. None of this means your case has been forgotten or that something is wrong. It simply means that immigration processing involves careful review of each individual situation. Let me take a moment to correct some common misinformation that spreads rapidly on social media and online forums. First, there is no secret priority system where certain nationalities or certain family categories are deliberately processed slower than others within the same classification. USCIS is required by law to process petitions in the order they are received, with some exceptions for cases involving urgent humanitarian situations or significant public benefit. Second, processing times are not getting indefinitely worse every year. While it's true that volumes have increased and USCIS faces resource challenges, the agency has also implemented efficiency improvements, hired additional officers, and expanded premium processing options for certain petition types. Third, you cannot pay extra money to speed up I-130 processing. Unlike some employment-based petitions, there is currently no premium processing service available for family-based I-130 petitions. Anyone who tells you they can pay to expedite your I-130 for a fee is either misinformed or attempting to defraud you. Finally, checking your case status online frequently does not slow down or speed up your case. USCIS systems are designed to handle status inquiries without affecting processing. You should absolutely check your case status regularly, but don't worry that you're causing problems by doing so. So, what should you realistically expect when you file an I-130 petition in 2026? Let's walk through the typical timeline. After you submit your properly completed I-130 petition with all required supporting documents and the correct filing fee, you should receive a receipt notice from USCIS within 2 to 3 weeks. This receipt notice contains your case receipt number, which you'll use to track your case online. For the next several months, you may see very little activity on your online case status. This is completely normal. USCIS officers are reviewing thousands of petitions, and your case is in queue. Most petitioners do not receive any communication from USCIS during this waiting period, unless USCIS needs additional evidence, which would come in the form of a request for evidence, or RFE. If you receive an RFE, respond promptly with exactly what USCIS is asking for. Delays in responding to an RFE can significantly extend your processing time. As your case approaches the processing time range published by USCIS for your service center, you should see your case status update to indicate that it's being actively reviewed. Eventually, you'll receive either an approval notice or, in rare cases, a notice of intent to deny if USCIS has concerns about your petition. If your petition is approved, the approval notice will be sent to you, and your case file will be forwarded either to the National Visa Center if your beneficiary will process through a U.S. embassy or consulate abroad, or to USCIS field offices if your beneficiary is adjusting status within the United States. Now, here's something that causes confusion for many families. Even if your I-130 is approved quickly, that does not necessarily mean your family member can immediately immigrate or receive their green card. For immediate relatives of U.S. citizens, visa numbers are always available, so once the I-130 is approved, the beneficiary can generally proceed relatively quickly to the next steps. However, for family preference categories, there are annual numerical limitations on how many immigrant visas can be issued. This means that even with an approved I-130, beneficiaries in these categories must wait until a visa number becomes available according to the monthly visa bulletin published by the U.S. Department of State. For some categories and countries, this additional wait can be several years or even longer, depending on demand and per-country limits. This is not a USCIS processing delay. This is a separate statutory waiting period created by United States immigration law. The priority date, which is the date USCIS received your I-130 petition, determines your place in line for visa availability. Let me share some practical guidance for those of you who are currently waiting for your I-130 to be processed. First, be patient, but also be proactive. Check the USCIS processing times page regularly to see if your case falls outside the normal processing time range for your service center. If your case has been pending significantly longer than the posted processing times, you have the option to submit a case inquiry through the USCIS website or contact the USCIS Contact Center. Second, keep your address updated with USCIS. If you move during the processing period, file Form AR11 to report your change of address and also update your address online through your USCIS account. Missing important notices because USCIS has an old address can cause serious delays and complications. Third, do not assume that silence means something is wrong. Most I-130 petitions are approved without any requests for evidence and without any interview. The petitioner usually does not hear anything between the receipt notice and the approval notice. Fourth, avoid the temptation to file duplicate petitions thinking it will speed things up. Filing multiple I-130 petitions for the same beneficiary without a valid reason will not accelerate processing and may actually create confusion and delays. If you're thinking about filing an I-130 petition in 2026, let me give you some advice to help your case go as smoothly as possible. Take the time to complete your petition carefully and thoroughly. Incomplete petitions or petitions with insufficient supporting evidence are the most common reason for RFEs and delays. Include clear, legible copies of all required documents. For marriage-based petitions, include substantial evidence of a bona fide marital relationship. For parent-child relationships, include clear birth certificates and evidence of any legal name changes. For sibling petitions, include documentation proving you share at least one common parent. Translations of foreign language documents must be complete, accurate, and certified by a qualified translator. Pay the correct filing fee using an accepted payment method. And perhaps most importantly, if your situation involves any complexity at all, such as previous immigration violations, prior marriages, adoptions, or legal name changes, consult with a licensed immigration attorney before filing. An experienced attorney can identify potential issues in advance and help you present your case in the strongest possible way, potentially avoiding RFEs and delays. Let me address some rumors that have been circulating in immigrant communities about changes to family-based immigration. There have been various policy discussions and legislative proposals in recent years regarding changes to family preference categories, elimination of certain categories, or modifications to the I-130 process. As of today, in early 2026, these remain proposals and discussions. They are not law. United States immigration law can only be changed through an act of Congress signed by the President. Administrative agencies like USCIS can modify procedures and issue new guidance, but they cannot eliminate family immigration categories or fundamentally change who is eligible to petition for family members. If you are eligible under current law to file an I-130 petition, that right exists today. If you hear claims that family-based immigration is being eliminated or that certain categories will no longer be available, do not panic. Verify that information by checking official government websites, particularly USCIS.gov and state.gov. Major changes to immigration law are widely reported by legitimate news sources and are announced officially by USCIS with implementation timelines. Immigration law does not change overnight. There are always transition periods and effective dates. And remember, approved I-130 petitions establish your place in line. Even if laws change in the future, petitions filed and approved under existing law generally maintain their validity. For those of you who are lawful permanent residents petitioning for family members, I want to emphasize something that can significantly benefit your family. If you are eligible to naturalize and become a United States citizen, doing so before your I-130 is approved can have major advantages. When a lawful permanent resident becomes a U.S. citizen, certain family members automatically move from preference categories to immediate relative categories, which eliminates the visa waiting period. For example, if you're a permanent resident who petitioned for your spouse and unmarried children, those beneficiaries are in the F2A preference category with limited visa numbers. But if you naturalize before the visa interview, your spouse and unmarried children under 21 become immediate relatives of a U.S. citizen, and visa numbers are immediately available. This can save years of waiting time. Similarly, if you petitioned for an unmarried son or daughter over 21 as a permanent resident, that's the F2B category with significant wait times. But if you naturalize, your unmarried children move to the F1 category, which often has shorter wait times. Becoming a United States citizen also means you can petition for your parents and your married children, which permanent residents cannot do. So if you've been a permanent resident for at least 5 years, or 3 years if you obtained your green card through marriage to a U.S. citizen and you meet all the naturalization requirements, seriously consider naturalizing. Not only does it provide the security and benefits of U.S. citizenship for yourself, but it can dramatically accelerate your family's immigration timeline. Let me also address those of you whose I-130 petitions have been denied or are concerned about potential denial. An I-130 can be denied for various reasons. The most common include failure to prove a qualifying relationship, concerns about the validity of a marriage such as suspicion that it was entered for immigration purposes only, missing evidence or documentation, ineligibility of the petitioner or beneficiary, or previous immigration violations or fraud. If your I-130 is denied, the denial notice will explain the reasons. You typically have several options. You can file a motion to reopen or a motion to reconsider with USCIS if you believe the decision was incorrect based on the evidence you provided or if you have new evidence. You can file an appeal with the Administrative Appeals Office in some cases. Or you can file a new I-130 petition addressing the issues that led to the denial. Each situation is different, and this is absolutely a time to consult with an experienced immigration attorney. An attorney can review your denial notice, evaluate your options, and guide you on the best path forward. Do not simply give up if your petition is denied. Many denials can be overcome with proper legal guidance and additional evidence. I also want to speak directly to those of you who are considering withdrawing your I-130 petition or who are being pressured to do so. Sometimes family circumstances change, sometimes relationships end. Sometimes beneficiaries decide they no longer wish to immigrate. If you genuinely need to withdraw a petition, you can submit a written request to USCIS. However, be very careful if someone is pressuring you to withdraw a petition, particularly in situations involving domestic violence, control, or abuse. Some petitioners use the threat of withdrawing a petition as a means of control over a beneficiary. If you are in this situation, know that there may be legal protections available to you, including self-petitioning options under the Violence Against Women Act, which applies to both women and men. Seek help from a domestic violence organization or an immigration attorney who specializes in these situations. Your safety is the most important priority. As we move through 2026, it's important to stay informed about any procedural changes or updates from USCIS. The agency periodically updates forms, modifies filing procedures, implements new online systems, and adjusts processing strategies. For example, USCIS has been transitioning to online filing for more petition types, expanding the use of online accounts where you can view case status and documents, and implementing video interviews in some situations. These changes are generally designed to improve efficiency and customer service, but they also mean that you need to stay current on proper procedures. Always check the USCIS website for the most current version of forms before filing. Always follow the current filing instructions. And if you're working with an attorney, make sure they're staying updated on these procedural changes. Let me give you some final practical advice as we conclude today's discussion. First, organize and keep copies of everything. Keep copies of all forms you submit, all evidence you provide, all correspondence from USCIS, all receipts and notices, and all documents related to your family relationship. If anything is ever lost or questioned, you'll have your records. Second, be reachable. Make sure USCIS always has your current mailing address, email address, and phone number. Check your mail regularly. Check your email regularly, including spam folders. Respond promptly to any USCIS communications. Third, be truthful always. Provide accurate information on all forms and documents. Do not exaggerate or minimize facts. Do not submit fraudulent documents. Immigration fraud can result in permanent bars to immigration benefits and even criminal prosecution. Fourth, understand that immigration is a marathon, not a sprint. The process takes time. Prepare yourself emotionally and financially for the reality of waiting periods. And fifth, invest in professional help when appropriate. Immigration law is complex. A qualified immigration attorney can save you time, money, and heartache by guiding you correctly from the beginning. Remember, while we've talked extensively today about processing times and procedures, we're ultimately talking about families. We're talking about husbands and wives who want to build their lives together. We're talking about parents who want to be reunited with their children. We're talking about brothers and sisters who have been separated by distance and circumstances. We're talking about families who deserve to be together. The I-130 process is not easy, and the waiting is not easy, but thousands of families successfully navigate this process every single year. Your case is moving forward even when it feels like nothing is happening. Trust the process, stay informed, remain patient, and keep hope alive. The information I've shared with you today is based on current USCIS procedures and processing times as of early 2026, drawn from official government sources. However, every immigration case is unique, and the information in this video is general educational information, not legal advice for your specific situation. For personalized guidance on your case, always consult with a licensed immigration attorney who can review your individual circumstances and provide advice tailored to your situation. Always verify information by checking official government websites, particularly USCIS.gov for USCIS information and travel.state.gov for Department of State information. Be cautious of immigration advice from unofficial sources, social media rumors, or unlicensed practitioners. If you found this video helpful in understanding I-130 processing times and what to expect during your family immigration journey, I invite you to subscribe to Immigration News Today. We're committed to bringing you accurate, up-to-date information about immigration policies, procedures, and timelines so you can make informed decisions for your family's future. Turn on the notification bell so you never miss an important update. Please give this video a like if it provided clarity during what I know is a stressful and uncertain time. Share this video with family members, friends, or anyone in your community who is going through the family immigration process or considering filing an I-130 petition. Your share might be exactly what someone needs to hear today, and please leave a comment below. Tell us where you are in your I-130 journey. Let us know what questions you still have. Suggest topics you'd like us to cover in future videos. We read every comment, and your input helps us create content that serves you better. Thank you for trusting us with your time today. I wish you and your family strength, patience, and success on your immigration journey. We'll see you in the next video.